What if your client says in a sexual assault case, guys, I have lots of people who will testify that I'm a good person and I wouldn't do this. Is that admissible?
We hear that all the time. Just ask everybody that knows me. They'll tell you I'd never do this.
I'm a good guy.
No, but it's more than that. I have witnesses who will testify that I'm a good person and I would not commit a sexual assault.
Right. And so, with sexual assault, this is a very specific kind of case where it doesn't matter how you appear in public. These are things that happen behind closed doors.
Closed doors, of course.
And so it doesn't matter what other people think. They can't testify as to what happened in that particular instance where you're accused of having behaved differently than what other people know. And, I think it's fairly well known that people can behave in one way in public and behave a totally different way when they're in private.
There's no better example. It's a little extreme. Who's the colonel who's like top 5 dangerous offenders in Canada? He was a colonel. And,
oh, really? Okay.
And he was extremely well thought of, not only in the military, but he was up there with respect to government, extremely charismatic, bright, excellent service record, and he turned out to be a serial rapist and murderer.
Yeah, and actually the cross-examination was brilliant on him, and it's available on YouTube. I can't remember his name, though.
It wasn't a cross-examination. It was
the interrogation.
One of the best interviews done by a police officer.
Interrogation, yeah.
Right on the Reed method, which is from the United States, and it was classic, textbook, and brilliant. And that's why, because he confessed. But this is an extreme example, but you can have people who appear in many ways at work or in their social life and everything to be a completely wonderful, upstanding, law-abiding individual, but when it comes to sexual offenses, and even domestic offenses as well.
I was going to say, any private offenses that take place
in
behind
private
closed doors, right?
But there's also case law, which I'm not reading from at the moment because I'm trying to find something else. Case law that says in sexual assault cases, well, you can call good character evidence, but it is of exceptionally limited value. To the point that in 32 years, I have never called good character evidence in a sexual assault case, and I've lost 5 cases?
Yeah. Primarily good character evidence is only useful in sentencing if somebody gets convicted.
Well, but let's just first deal with trial, because I just want to put this to bed because people have asked us about this.
We get this all the time, though, from our clients saying, I have all these witnesses, what a great person I am. And they also want to testify about, I'm not the kind of person who would do this. And every single time you say to them, do not put your character on trial.
So, yes. So let's just frame...
There's a reason for that.
Right, but let's just frame things so people understand the law, okay? Because we got comments from our viewers asking about this.
Why don't we talk about what it is?
What is?
Good character evidence.
Okay, what it is, but I just want to be clear. In sexual assault cases, there's actually case law that says not of any value.
Not of any value,
okay,
right.
Go ahead. What is good character evidence?
So good character evidence.
And what's it restricted to?
Just so you and that's what makes it so almost useless in this day and age, because it's defined as the evidence of good character is limited to the accused's general reputation in the community with respect to relevant traits such as honesty, morality, and humanity. This can include business community reputation. The witness, however, cannot give any personal opinion on the accused's character, rendering it almost not that helpful.
They're not allowed to say whether or not they think the person would have done what they're accused of.
Right. It has to be someone who has a general reputation. Like, say it's a small knit community, a small town. Okay, this shopkeeper is known for being honest. He's a good guy. But in a huge, ginormous city, like, it's very difficult now to actually lead good character evidence.
And when you do that,
it's possible.
There are people who will, within their business circle and their social circle, and they could be a member of a church or a synagogue or a mosque.
Right.
They can be, philanthropic and all sorts of things. And you could probably find credible witnesses to testify to that.
It's just hard.
But more importantly, it's still going to be of restricted value.
Right.
And when you do put your character on trial, then it opens it up for the Crown to bring bad character evidence.
So you put your character in evidence only when you testify. So an accused testifies, and then the accused will call character evidence. Can the Crown rebut that? Yes. Can they reply to that?
Yes.
And what are the limitations on that?
Well, they can't go into propensity evidence, for example.
Right. And what type of evidence are they allowed to call?
Criminal record.
So if they don't advance at the beginning, they could, if they dug up let's say they didn't notice a prior criminal finding of guilt or a conviction, because now you put your character in issue.
That's right. Anything goes that way.
Or they could also call reply witnesses to say their general reputation for honesty and integrity is bullshit. Right. So they could call the same type of evidence to refute what the defense has called. Right. But that's sort of the guardrails and what they can do in reply if they've not advanced a character application at the beginning of the proceeding. Right. But let's just focus just a couple more minutes on good character, because this was like a major issue that people were messaging and commenting on that they wanted the explanation on. And really, I just never, I think maybe I've called it in one case. Maybe.
I mean, it would be more relevant if the allegation was something that was alleged to have taken place in a more public kind of space, right? Like, if it related to something that other people could have witnessed similar occasions. But like we've been saying, if it's a sexual assault allegation, these are things that generally take place when nobody else is around. Right. And so there's a specific difference in circumstances that don't match what a general good character witness.
But just so everybody understands, again, there's a definition and there's a limitation as to what you can call as good character evidence. And again, it's general reputation evidence.
Right. And the jury instruction, if you want to be more precise,
that'd be great.
Where the accused puts his character in issue, the judge must instruct the jury on the permissible use of this evidence as being relevant to two things: the unlikelihood that the appellant committed the offense charged, and the credibility of the appellant as a witness in the proceedings. So both very narrow.
So when you say appellant, because that was on appeal, the accused.
The accused, yeah. Both very narrow circumstances.
It is a lot less common for good character evidence to be at issue, and much more common for bad character evidence to be called by the Crown.
Yeah, so since we're talking about it, we've done this, I think, in 2 other episodes. So let's revisit, bad character evidence.
Yeah.
But just footnote.
I just remembered it was like you have ZWC and MRS is the other one.
MRS. Yeah, there's an MRS, and when you look
they came out very close together.
We've got MRS here in our internal memo.
Our internal cheat sheet, yes.
That's from ONCA, the Ontario Court of Appeal.
2020 ONCA 667. It's a unanimous decision. Justice Pacheco rendered the decision.
And ZWC came out shortly afterwards from Ontario Court of Appeal. And both of them are very consistent and a very strong message about the limitations on bad character evidence being called by the Crown, which normally takes the form of a complainant making allegations that the person's not charged of, but they're making allegations about prior bad behavior that tries to set up a pattern of behavior that makes them more likely to have committed the offense.
Yeah, so let's deal with this more in general for a moment. So evidence of prior discreditable conduct is the terminology used. And those are prior acts of bad character. They are presumptively inadmissible. So the Crown must bring an application in order to introduce such evidence, and they have to lay out a foundation as to what the evidence is relevant to and how probative it is versus how prejudicial it is in order to be admitted. And you can have it done in many cases. You can have it done in homicide cases. You can have it done in drug cases. You can have it done in domestic-related cases, okay? But domestic's a bit different, and we'll come there in a moment. So generally speaking, they have to bring this application, and they have to ground the relevance and probative value.
Before trial.
Before trial. And when we're talking about cases where there are multiple counts, so let's say there's multiple charges, it commonly happens in cases of a domestic nature. So it's a multi-count information or a multi-count indictment, meaning if it's in the provincial court or superior court. So if you want cross application of evidence from one count to the next, MRS speaks about this. Again, you must address this ahead of time in almost the form of an application to get permission from the court to have the evidence apply from one count to another, which is in essence using the character of one offense to the other. And in the other area is similar act evidence or similar fact evidence, where you've got cases like Handy and others that talks about other acts of bad conduct that may be charged or uncharged, where the Crown can bring an application to say, because of the striking similarity and the modus operandi and the way these offenses have occurred, and this other evidence, whether it is actually charged or not, makes the complainant more believable. It has...
I was just going to say, so can you repeat that for us? Those two scenarios, because it's confusing. One is cross count, that's within a trial. Right. So information that's already before a trier of fact.
If you believe one count, then it makes them more likely to have committed the other counts.
Right. The other is totally unrelated information from outside of the trial.
So let's take a case where you have, let's go to our jam here, a sex assault case, okay? So let's go, and we've done the drug work and all that other
violence.
stuff.
We do a lot of...
But we've got, so these are the ones you see this a lot. So you've got, in a case, let's say, 2 sexual assault charges, okay? Let's say they start out as 2 separate investigations, okay? You meet, the accused is alleged to have met somebody over a dating app. They meet and they go, he brings them home, gets them drunk, and sexually assaults them, and they leave there crying, and they go to the police, within a couple of days afterward. But there's a certain type of conduct which is all very distinct. There's another investigation. Somebody comes to the police and says... A month later and says, I met this guy on this dating app. He suggested that we get alcohol. I thought that was cool. But then I thought we were going to go out. We wound up going to his place. We got drunk. I got sexually assaulted.
And reports right away.
And I reported to the police later that night.
So very similar modus operandi.
Right. So what's similar? What's similar? Well, they meet over a specific dating app. Okay. The individual uses the same name. Alcohol's involved. The way the evening unfolded, instead of going out for dinner or going out to a bar, winds up redirecting to a private location. These are all...
And both complainants did not know each other at all.
Right. Nobody knew each other. Right. So there are hallmarks of each complaint that are really quite similar. They're distinct and they're strikingly similar, let's say that. And there can be other elements as well. We're just making this a little bit more simpler. And so in that case, the Crown can say, okay, well, I'm going to join these up now on the same charge, or I may run one but call the complainant on this one that I'm running and then call them on the other one. But what makes the most sense is to join them up on the same information or indictment and run it together. And there, the Crown's going to bring...
A similar fact application.
Cross count, right?
Well, no, a similar fact application. Yeah. And it's also like similar count.
Which works as bad character evidence.
Right.
Worse, okay? Much worse. This is similar act evidence. So what they will say is these two complainants who don't fucking know each other, who have no chance of colluding, have very striking similar descriptions of how they met the individual, how the date went, and how they were sexually assaulted. And that evidence is powerful evidence to support the credibility of each complainant. That similar act or similar fact, however you describe it, there's a specific application, there's case law on point, which has been in existence forever.
And what would not help in this instance? It would not help to have good character evidence saying, this guy, I know him, I've known him for years, and he opens the door for women, and he's super polite.
That's right.
That's not going to help.
But don't you think the average person finds this all artificial?
Yes.
A judge is already hearing the case, right? Why does the Crown have to bring any application? The judge is going to hear facts from both cases.
Or jury, if you're in front of it. Because there is ripe of abuse. So there needs to be careful, guardrails in place with respect to introducing evidence that can have that kind of a powerful effect. So it has to meet certain levels of acceptability. Let's just put it that way. And that's very important because it has to be, frankly, strikingly similar. And that's why you have cases like Handy.
That's the leading one, I think.
That's the leading, and it's from a long time ago, and we can give the citation on it. But, it's very important so that it's in for distinct purposes. You also have to be careful about propensity reasoning. It's not just that they're more likely to have committed offense because they're also charged with something else, but there has to be this level of probative value that it's so strikingly similar that then it overcomes that prejudice. And again, it's still not for propensity, it's for the similarities between the two, that the chance of it coincidence and is really not there, and there's no chance of collusion here.
What's the difference between the two?
To what?
Propensity versus the other one, similarity.
Propensity is simply because if you commit one offense, you can have somebody accused of a domestic assault and then a sex assault. Will that get you anywhere in a similar act application? No.
Right.
Propensity reasoning is because they were found guilty of an offense or they are facing
Charged.
another assault charge and a sex assault charge, that they're more likely to have committed the offense because there's a list of alleged criminality. And that's not admissible. Right. It's not permissible. That's wrong. Propensity reasoning is, and you've got to be very careful because the jury, there has to be very strict instructions as to how a jury will apply it. And judges themselves will be very careful as to how they instruct themselves and how they set it out in their reasons to ensure that they don't cross over into the impermissible use.
One of the reasons they do allow bad character evidence at trial for limited purposes is to explain a pattern of animosity towards the complainant, and also to explain why the complainant didn't report earlier.
So you're talking about domestic cases.
Right.
And so this is something a bit different. So let's talk about this for a moment. So in domestic relationships, okay, and domestic abuse allegation cases, the rules are somewhat different. So you can bring forward uncharged prior discreditable conduct evidence in intimate partner violence cases, okay? This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you. And this is slightly different. So evidence of uncharged prior discreditable conduct has been frequently admitted in domestic violence cases to describe the nature of the parties' relationship, sometimes referred to as context or background. And it's on that basis that evidence can have probative value for a number of reasons, one of which you mentioned is animus. Where such evidence demonstrates a strong disposition to act violently or sexually towards the victim, it is not being used to prove the bad character of the accused, to support an inference that the accused is disposed to act violently towards the victim, or that they have the disposition, but it has probative value in showing that there is a dislike or animus from the accused to the complainant. Now you try and distill that one out. Good luck.
Good luck.
Okay.
Right. Yeah.
But that's the animus exception. And also, sorry, just one more second. And it can be also used to show that they have little to no regard for the accused bodily privacy or consent. Again, going to animus.
Or I just had one where it was very interesting. You raised that, where it was Crown was bringing the application. Incident number 1 involved a alleged throat grab, and a threat. Charge before the court involved him throwing her over the balcony. You would see, it would appear no real connection, but the judge said, well, she's testifying on the second time the reason she left the apartment, went onto the balcony, was because she saw signals. She testified about those same signals on the first occasion. Right. So that's why it got let in.
So and then also to explain for the Crown why it is she stayed in the relationship, because she was terrified and afraid for her life and thought that if she left she might be killed or something like that. So there's some role in the Crown's case to say that all of these other things are to explain why
her behaviors.
Yeah, and especially with a jury trial where the jury might think, well, why the heck did you stay? Right.
So let me just itemize the generally accepted areas for it to go in. And I'm referring to a case called 𝐔𝐗, which is, I believe, Justice Watt's decision. So it can go in as part of narrative of relevant events, which is scary because it can be quite large, but that's been narrowed down more now, to provide context for other evidence. And that could be, if it's a highly abusive relationship, delayed disclosure, why a complainant might stay in the relationship. And we all know that this would be discriminatory beliefs anyways. To facilitate understanding of the nature of the relationship between the principals, to demonstrate animus, but also motive on the part of the accused for committing the offenses, to explain the failure of the complainant to leave the relationship or to report abuse earlier, and to rebut a claim of fabrication. Those are generally the standard categories in which this evidence can be admitted. And one of the leading cases is DSF. Let's see if I can get the citation for everybody. I'll find it in a little bit, and I'll make sure that we post it up. But these are the leading cases on it, which still exists. And you still need to bring an application now of prior discreditable conduct in order to admit that in domestic cases. I got to tell you, years ago, it wasn't that stringent. Years ago, to admit this in a domestic case was almost like
It's part of the
it's
narrative.
just part of the narrative.
Right.
It's going to go in because it's going to explain these things. So you would talk about it at the trial, but it's not like there'd be a formal application. And I still think there are certain prosecutions where they believe you can just call the evidence according to DSF and other cases. We take the position, and I think this is the standard and the gold standard in practice now, is to formally bring that application, because you can wind up having an unsafe conviction and go up in appeal and get it reordered down for trial. But this is important to know. This is distinct and different from all those other areas of bad character evidence. And this is really, really, really important to understand. Domestic cases of sexual abuse or violent abuse in intimate partner relationships, it's a whole different category and a very large swath of areas where evidence can be admissible. And that's where you often find these multi-count indictments or informations as well.
And to tie it back to like good character evidence, if the Crown's leading bad character evidence from the complainant, then it does open it up conversely to the accused being able to say, the complainant said that in a public space, I treated her or him in a certain way. And then if you have witnesses that were there who can say, no, in fact, I saw the opposite or something, that in fact out in public, the behavior that's being described did not exist, then it could open it up for good character evidence having some value to counteract a claim being made by the complainant, right? But that's very rare.
It's very rare.
So, as I said, cases like ZWC and MRS really put what I think is the firm, I keep using this, it's like a term everybody likes using now, guardrails. Formal guardrails on how this can be used, and the fact that you need the application, okay? And that's very important. And, there can be situations where, having assessed prejudicial effect of the proposed evidence, the trial judge determines that the evidence is so prejudicial that it has to be excluded, or the judge can determine we can admit some of it and not others. Or even if they admit it, there's still a prejudicial effect, and the judge has to take steps to mitigate that prejudicial effect, which is by instructions to a jury if it's a jury trial, or to themselves, and they'll put it into their written reasons. But it's a very important area of law, because it is distinctly different in intimate partner violence cases than it is in all those other areas of law.
Yeah, and I think really what it comes down to at trial is that you can't count on other people to testify for you. You have to be able to do what's the prime goal of storytelling: show, don't tell. You don't tell people I'm a good person. You have to somehow show it. And that is a factor of how you respond to questions, how you address the allegations, and how you present yourself in court. You have to show who you are. You can't just simply go in there and say, I'm a good person.
Let me just, sorry,
I was just going to say, just a footnote on this good character evidence stuff. Don't forget sentencing. Sadly, if we ever get there, I do use good character evidence on sentencing.
That's where it's most common. That's where it's most common.
Forget. Yeah, that's exactly
Look,
right.
I can imagine that there can be cases where somebody's life has been so well led that it just cries out for some balancing as to who this individual is, regardless of the allegations. And, I had a client on a homicide case where he basically, World Vision came to the bail and was part of, we won at the prelim, so I didn't need to call it later on, but he had saved over 1,000 people from a country where they were being persecuted. Like, this was incredibly community minded. The entire family was involved, and it happened to be a homicide. But now that I'm talking about a homicide for cases and we're talking about bad character, what's a Scopoletti application? Remember that? You haven't done one of those in a while, eh?
I thought it was a pasta dish.
It's actually veal with a side of pasta.
That's right. That's all I remember about scappellati.
So you can have a deceased, or even on an attempt murder, a victim, where they are notorious. They have a long criminal record for violence, and you may be running a self-defense argument. So let's say this happens often, and it could be a shooting or a stabbing, where there's a self-defense argument, and the deceased victim has an incredibly long and pointed criminal record for violence. And then you can bring an application to admit evidence about the victim's criminal record. And there may be other witnesses who are associates of the victim, where you can cross-examine on the criminality. And that has to be by way of an application brought by the defense. In certain instances where it's very apparent, a good Crown attorney will concede that, and there has to be limits on that. But then that will support a self-defense argument, because it supports to a certain extent if the person is knowledgeable of the deceased's criminality and the fact that they've often shot people or carried a weapon and they have a hot temper and they have a long record, that their perception of imminent risk is more reasonable given all of those circumstances. So that's where character evidence can come in as well. I just wanted to close the loop because it's relevant in self-defense cases in particular.
That's right.
Yeah.
I hope we answered everybody's questions on this one, because we keep coming back to bad character. What I do like is with these cases of CWC, MRS, in combination with the other ones, the Court of Appeal has done an excellent job of delineating how it should be, how the applications are brought, how they're supposed to be worked through, and how evidence can be applied and then mitigated if it comes in. So there's very good law on this, and it's extremely helpful when you're in situations like that. But be mindful of how the seepage is, especially in these domestic assault cases, where we commonly deal with stuff arising out of high conflict divorces, and this arises all during the high conflict divorce, and it's years of abuse. The entire trial will be a smear job. So you got to be very attuned to the actual issues and be on top of it.
Focus on things that matter, and don't expect other people to be able to come in and testify that you're a great person who would never do what you're accused of. It just doesn't work that way.
No, but how to deal with that is that's not fatal. Like it again, as we're saying, it's not 33 years at the bar, 32 years at the bar. Like the times that we've called this, I can't really remember. I think it's been in one case. It's about how you present to the court. Mm-hmm. It's about how you testify. It's about how reasonable you are, how you admit that there are things that are problems with yourself. We were in an argument. I yelled. I called her names. I shouldn't have done that, but I didn't hit her. It's your presentation. It's the coherence. It's your delivery. It's everything. You can successfully defend yourself against a host of allegations, a host of alleged bad character evidence, but it's on how you present and
don't have to be an angel.
How your evidence has to come together. And that's a good point. Nobody's an angel.
No one's an angel.
Shit happens.
Yep.
As long as you own up to it.
Yeah.
It's like when we deal in other cases like a sex assault, did you have the opportunity to do it? Oh, I was never with the person alone.
Right.
Be fucking reasonable. Of course I was alone with them,
Right.
These are things that are reasonable to admit. So it's not fatal that you can't bring in good character evidence. You can if you really want to, but it's
worth it.
It's really, and the chances of something going wrong can be a problem too.
Yep.
So.
Yeah.
Huge.
So there we go. That's the answer to a question from one of our viewers who...
And thank you for it.
We really appreciate, when people send us topics that they want to hear us talk about. And don't forget to like, comment, subscribe, and share the videos, hit notifications so you get to see every time we have a new video come up.
Keep those comments and emails coming in. Good night, everybody.
Yeah.
Thank you.
Thanks for watching.
Don't forget our sponsor, EasyDNS. Because
You're a client.
I'm a customer, yes.
Good night, guys.